Hello everyone, welcome back. In today's session, we'll quickly cover the most important current affairs updates that are highly relevant for your upcoming government exams. Make sure you watch till the end because every point we discuss can help you secure that extra mark in the exam. So without wasting time, let's start with the today's quote of the day. Nothing is impossible. The word itself says I am possible. Here is the first news item. Modi degree row, Delhi HSC quashes CIC's permission to inspect university records. So, what are the important keywords here? One is HC, which means High Courts, and second one is CIC, which means Central Information Commission. So here it's a little bit typo is there. So please consider Central Information Commission. So first we'll check the important onliner facts on High Court, which is relevant for UPSC or other government job. As per Article 214, there shall be a High Court for each state. That means every state should have a high court, must have a high court. Like West Bengal is my state, so West Bengal has a high court. Similarly, UP, MP, these are different states, so they also must be have. They also should have the high court. Next, as per Article 215, High Court is a court of record with power to punish for contempt. That means whatever record High Court has, that should have evidentiary capacity. And if anyone disobeys High Court's order, High Courts will have the power to punish that person for disobeying. Next, as per Article 226, High Court can issue writs for enforcement of fundamental rights and other legal rights. So here, what are the fundamental rights? That's already mentioned in the Constitution, right? So that means right to equality, right against discrimination, prohibition of discrimination. All these are the fundamental rights. Right to life. So a lot of things we will cover in some days. All the fundamental rights. Okay. Now, if we compare Supreme Court and High Court here, so Supreme Court also can issue writs, and that is only for enforcement of fundamental rights. But High Court can issue writs both for fundamental rights as well as other legal rights. That means High Court has wider coverage for enforcement of the wider coverage for issuing writs. Next, as per Article 227, which gives High Court power to superintendents over all the subordinate courts and tribunals. That means whatever subordinate courts, district courts are there, High Court have the power of superintendents. So first High Court in India is Calcutta High Court, which was established in 1862, followed by Bombay High Court and Madras High Court. These are the three oldest High Courts in India. Next, as per Article 231, Parliament may establish a common High Court for two or more states or UTs. So currently, India has total 25 High Courts, but number of states and UTs combined are more, right? Then that means there must be some High Courts which is covering more than one states. One example is Punjab and Haryana High Court, which is covering both Punjab and Haryana state along with UT or Union Territories of Chandigarh. Similarly, Bombay High Court covers Maharashtra, Goa, Daman and Diu and Dadra and Nagar Haveli. Then similarly, Madras High Court covers state of Tamil Nadu and Union Territories of Puducherry. Next, so President appoints the High Court judges under the Article 217. So based on that consultation with Chief Justice of India, Governor of that state, and Chief Justice of that High Court. High Court judges normally serve till the age of 62 years. That is also as per Article 217. President can remove the High Court judges based on proven misbehavior or incapacity through a special majority impeachment motion. And that is under Article 217, read with Article 124 of 4. Okay, so here on important keyword, that is special majority. What is it? Special majority is, that means let's suppose one motion is someone presented in the house, let's suppose in Lok Sabha, then that motion should be passed by at least 50% of the total membership of that house. Along with that, at least 2/3 of that total membership should be present and voting. That is the special majority. Later, I'm going to discuss with the current strength what should be the exact number of the votes, like a winning candidate or the resolution needs to get to be considered as passed. Okay, and how many members should be present in the voting. So I'll explain that on in upcoming slides. So strength of high courts are determined by the president from time to time. That is under Article 216. High Court has original jurisdiction in matters like election petition, marriage and divorce. That also depends sometimes on the states. Okay. Next, it's regarding the judicial review power. So based on the Keshavananda Bharati case 1973, which reaffirmed judicial review power of high courts under Article 226. This is one of the most important thing, Article 226 and Keshavananda Bharati case, judicial review. So that basically, let's suppose Parliament brought out some law, and now judicial will have the power to review to check if that is violating the basic structure of constitution or not. If it is violating, then that act will be considered as void or null. Next, we have High Court read jurisdiction. So this is wider than Supreme Court, as I already mentioned, because this just not only covers fundamental rights but also the legal rights. So it has control over the subordinate courts. Then we have National Judicial Data Grid. What it does, it provides real-time data on pending cases both in high courts and the subordinate courts. So it helps to track. It helps make it more transparent. Next, we'll go important multi-liner facts on the same things, but here we'll have the explanation for each thing, which I already did. So here you can see India has currently total 25 high courts. I already explained that one. So please go through it. And all the judgment also I have mentioned. First, Article 214. This says that each state should have a high court, right? So now for that, basically we have mentioned India currently has 25 high courts. Next, on Article 215, High Court as a court of record. Here we have a judgment. The judgment is Delhi Judicial Service Association versus State of Gujarat, 1991. What it said, it reaffirmed contempt powers of the High Courts. That means if anyone disobeys the High Court's direction, then High Courts will have the power to punish that person. This kind of things basically High Court will have, and that is based on Delhi Judicial Service Association versus State of Gujarat, 1991 case. Next, Article 217. It talks about the appointment and tenure of judges. So here we have, I already mentioned the retirement age is 62 years. So here important judgment associated with it is second judge's case, 1993, which gives primacy to the judiciary in case of judicial appointment. So before this judgment, second judge's case, 1993, executive had primacy over judicial appointment also. So post second judge's case, 1993, it has changed. Now judiciary has the primacy in judicial appointments. Thus, the collegium system basically created. Next, Article 226, it talks about the writ jurisdiction. What are the writs? One is habeas corpus, then mandamus, then certiorari, prohibition, quo warranto. So it's basically High Court issues for enforcement of fundamental rights and legal rights. Okay. Now, here also we have some judgment based on this. This writ jurisdiction has been created. That's Keshavananda Bharati case versus State of Kerala, 1973. So, which reinforce the power of judicial review as a basic feature of the constitution. Now, if we discuss about the different types of writs, so first is habeas corpus. It means to have the body. That means when it is issued to produce a person who is illegally detained. Next, we have mandamus. In case of mandamus, the meaning of the mandamus is we command. It is issued to a public authority or official to perform a duty that they are bound to do. Let's suppose you went to get some caste certificate from BDO office or any government office, okay, SD office. Now they are denying it. They are not giving you that caste office illegally. That means you have produced all the required documents, whatever is as per the act is required, but they are denying you. So that time you can reach to High Court. High Court can issue mandamus so to that public officer to issue you a caste certificate if everything looks good. Next, we have prohibition, which means to forbid. Prohibition is issued by a higher court to a lower court or tribunal, prohibiting it from exerting its jurisdiction. Let's suppose you went to some tribunal and they gave you some judgment. Now, if the tribunal doesn't have the required power to give the judgment, then you can reach out to High Court, and High Court can issue prohibition asking that lower court not to exceed its jurisdiction. Next, we have certiorari, so which means to be certified. Certiorari is issued by a higher court to quash the order of lower court or tribunal if it acted without jurisdiction or violated natural justice. Next, we have quo warranto, which means by what warrant? Warrant is issued to prevent a person from holding a public office to which they are not entitled. Let's suppose someone has occupied the seat of a SDM, okay, but he is not entitled for that. In that case, High Court can issue quo warranto to summon that person. Next, we have Article 227 that talks about the power of superintendence. As I already mentioned, High Courts have the supervisory power over all the subordinate courts and tribunals in their territory to ensure proper administration of justice. So, for this also we have a popular judgment, that is Wariyam Singh versus Amarnath, 1953, which clarified that this power must be used to keep lower courts within their jurisdiction. Next, we have Article 235. It talks about the control over subordinate judiciary. Now, here we have a popular judgment, that is State of West Bengal versus Nripendranath Bakshi, that is 1966, which recognized High Court's primacy in controlling subordinate judiciary. So these are the judgment I have made. I am trying to mention judgment for each of the important facts. So you need to remember this thing. This will help you to enrich your main answers. Next, we have judicial review role. So high courts play a key role in striking down unconstitutional state laws and executive orders, thus ensuring constitutional supremacy. Here also we have a judgment, Supreme Court judgment, that is L. Chandrakumar versus Union of India, 1997, which held that judicial review by high courts under Article 226 is a part of the basic structure. Okay, so this can't be taken away. Next, we have a original and appellate jurisdiction. What is original jurisdiction? So basically, company law matters, writ petition, then election petition. These are the original jurisdiction of the High Court. And in case of appellate jurisdiction, so some civil and criminal case uh, from lower court can go to the higher court by the process of appeal. That is the appellate jurisdiction. Next, it's regarding the removal of High Court judge. How a judge of High Court can be removed? He or she can be removed by the President through a parliamentary process similar to Supreme Court judges. Now here, special majority is needed in both the houses. So what is special majority? That I am going to discuss in the next slide. Now here we have a important judgment, that is Justice V. Ramaswamy case 1993, which talks about first ever impeachment motion against a High Court judge, though the motion failed in Lok Sabha due to lack of majority. Now, this High Court has a role in strengthening the democracy because it strike down the unconstitutional law, right, or the ordinances. So that way it strengthened the democracy. So here also we have an important judgment, that is A.K. Gopalan versus State of Madras, 1950, and later Maneka Gandhi versus Union of India, 1978, which expanded the scope of Article 21 using the writ jurisdiction. Okay. Next, here I am going to explain what is special majority. When we say about majority, when we say about the majority, what does it mean? That means, let's suppose there are total 100 members. Now there is some discussion is going on. Now, when it comes about the voting, let's suppose if 51 members vote for that for one candidate and another 49 votes for another candidate, that means now the candidate which gets 51 votes, that he or she will be declared as winner. That is majority, simply. Okay. Now, what is special majority? So this I'll explain with the current strength of the Lok Sabha. Currently, Lok Sabha has total 543 members and Rajya Sabha has total 245 members. Okay. Now, 2/3 of the total membership of Lok Sabha, that means 362. For Rajya Sabha, that is 164. Now, these are the two-thirds. That means for special majority, at least 362 members of the Lok Sabha should be present and voting, and at least 164 members of Rajya Sabha should be present and voting. Now let's get the 50% of total membership. For Lok Sabha, it will be 272. This is rounded up value, and for Rajya Sabha, it will be 123. Right? Now, to pass a resolution, at least 272 votes from the Lok Sabha is needed, and for the Rajya Sabha, at least 123 votes is needed to pass a resolution. I hope this is now clear. Please let me know if you need more clarification. So now what you can do, you go through this diagram. Here I have mentioned it again. It will using this diagram you can remember this, for memorize this for a long time. Okay. Now we'll go through some practice questions on high courts. This is applicable for all government jobs. First, question number 1. Under which article of the Constitution is a high court established for each state? That is Article 214. So option B is the correct answer. Next question. What is the retirement age of a high court judge in India? That is 62 years, right? We already discussed. So option B is the correct answer. Next, which is the first high court to be established in India? That also we already studied. That is Calcutta High Court, which was established in 1862. Next question, who appoints the Chief Justice of High Court? That is, we already know, President of India. So option C is the correct answer. Next, question number 5, which article gives High Courts the power to issue writs? That is Article 226. We already know that. So for Supreme Court, what is the article? That is Article 32. So here, correct option will be option B, Article 226. Next, question number 6, High Courts have control over subordinate courts under which article? That is Article 235. That is also we already know, right? So option C is the correct answer. The removal of High Court judge is done through option A, presidential order alone, option B, Supreme Court judgment, option C, impeachment by parliament, option D, governor's approval. Correct option is option C, impeachment by parliament. Next, question number 8, High Court is a court of record under which article? That we already know, that is Article 215. So option A is the correct answer. Next, question number 9, which of the following is not a writ issued by the High Courts? So you know, habeas corpus is a writ, Then co-warranto, that is also reads. Then mandamus, that is also a read. So ordinance, that is not a read. That means option D is the correct answer. Question number 10 and the last question here. Parliament can establish a common high court for two or more states under which article? That is article 231. So option number A is correct answer. Next now let's go through some practice questions. This is specific to UPSC prelims. Question number 1. Consider the following statement about the high courts in India. Statement 1. They can issue writs only for enforcement of fundamental rights. Statement number 2. Their writ jurisdiction is wider than that of the Supreme Court. So first you see, High Court issues writ both for fundamental rights as well as legal rights. That means statement 1 is not correct. And only second statement, writ jurisdiction is wider than that of Supreme Court. That is correct. So option, so wherever only 2 is mentioned, that is correct. So B has 2 only. That is correct answer. Next question, power of judicial review of high courts in India is derived from. That is derived from Constitution of India. That's very clear. So option C is the correct. Question 3, which of the following articles deal with the appointment of high court judges? That is article 217. It's also a simple fact which we already mentioned, so you can remember this thing. Next, question number 4, the president consults which of the following before appointing a high court judge? State number 1, Chief Justice of India. State number 2, Governor of the state. State number 3, Chief Justice of the High Court. So here we could see all basically part of that committee which recommends to the president for high court judge appointment, right? So here the options which has all the 3 statements, that is the correct. That is option D, 1, 2 and 3. Question number 5, under which article can Parliament establish a common high court for 2 or more states? That is again simple fact, that is article 231. So option A is the correct answer. Now let's go through some practice question for UPSC main. So I'm not writing the answers here. So I'm just giving the questions. So what you can do, you can write by yourself and post in my Telegram channels. Okay, then everyone can check if that is that looks good or not. So first question number 1, explain the significance of article 226 of the Constitution. How is it different from article 32 with respect to writ jurisdiction? Write it in within 150 words. Next question can be, high courts are the guardians of the fundamental rights at the state level. Discuss with special references to judicial activism. Next question can be, discuss the procedure for the appointment and removal of high court judges. Highlight the role of collegium system. Next question can be, judicial review is a basic feature of the Constitution. Explain how high courts contribute to this function with relevant case laws. Next question can be, write short notes on original jurisdiction of high courts. Next can be, write short notes on control of high courts over subordinate judiciary. Now, till now, I think we have covered everything which is important in terms of government exams or UPSC. I've covered everything. So on high courts. Now let's proceed with the next item, next keyword, which was Central Information Commission. So what is Central Information Commission? Now we'll go through first the one-liner important facts, okay, which is relevant for government jobs. First, we'll know what is the constitutional basis for Central Information Commission. So it was established under the Right to Information Act 2005. So as it was established through Act, so it is not a constitutional body. So it is a statutory body. Next, how many members are there in the Central Information Commission? Total 1 Chief Information Commissioner and up to 10 Information Commissioners. So total at most it can be 11. 1 Chief Information Commissioner and then at most 10 Information Commissioners. So who appoints Information Commissioners? President appoint them based on the recommendation of a committee. The committee consists of Prime Minister, who acts as chairperson, then Leader of Opposition in the Lok Sabha, and a Union Cabinet Minister. So this change in committee happens after the 2019 amendment. Now the tenure, if we talk about the tenure, total 3 years or until the age of 65 years, whichever is earlier. So the Information Commissioner will be there. Now next, the removal process. Chief Information Commissioner or other Information Commissioner can be removed by the President on the ground of proved misbehavior or incapacity after the Supreme Court inquiry. That means, let's suppose if there is any allegation of proved misbehavior, or incapacity is there against a Supreme Court judge, against a High Court judge, then what will happen? Then President will form a committee of inquiry of Supreme Court judges. Now they will give the findings. If it is proved that misbehavior or incapacity is there for the associated with that judgment, then basically President will remove that judge of the High Court. Next, we have State Information Commissioner. Here it is basically headed by State Chief Information Commissioner and similarly plus up to 10 State Information Commissioners. So they are basically appointed by the governor. Now, who recommends their names to the governor? A committee led by Chief Minister of that state. Now, who is our current Chief Information Commissioner of India? That is Hiralal Samaria. Now, if we talk about the powers, so Information Commission, Central Information Commissions have the power of a civil court. So it can summon, enforce attendance, receive evidence on affidavit, etc. Now, it also hears appeals and complaints regarding denial of RTI. So its decisions are binding on public authorities. Now there are some exceptions also there that is mentioned in section 8, like national security, privacy, company secret, trade secret kind of thing. So it's under exception. So if you ask anything on national security, the public officers will not give you that information, and that is not basically violating the act also. Now here in this regard we have a landmark case, that is Anjali Bhardwaj versus Union of India 2019. So here Supreme Court directed timely appointment of Central Information Commissioners and State Information Commissioners. Now, the same thing again, in the same way, we'll now discuss with the multilinear facts. This will be mainly helpful for UPSC. So first, if we talk about the legal basis, it's based on the Right to Information Act 2001, right? Right to Information Act 2005, right? So here, what it is significance? They enforce citizens' right to information under Article 19 of 1 of A. What is it? It's talks about the right to freedom of speech and expression. Now next we have composition. We already know, like on Chief Information Commissioner and up to 10 Information Commissioner. In state level also the similar structure. In case of appointment process, we know who appoints them. President appoints them based on the recommendation of a committee consisting of PM, Leader of Opposition Lok Sabha and Union Cabinet Minister. So in case of State Information Commissioners, so they are appointed by the governor based on a recommendation of a committee led by CM, Chief Minister of that state. So tenure, everything we know. Power also we know that this act as a civil code. Then appeals and complaint. Now let's suppose you have asked for some information. Now if public officer, information officer make it delay like more than 30 days, in that case more than 30 days or even more than 48 cases in case of life and liberty. So for each day there will be fine to that public officer, that is 250 rupees per day, and maximum it can be 25,000 rupees. Now binding nature of decision. Next, we have judicial review and independence. That's all already discussed. So we have a important case regarding RTI and fundamental rights, that is State of Uttar Pradesh versus Raj Narayan, 1975. Here Supreme Court held that right to know is a fundamental right under Article 19 of 1 of A. That means it can't be denied. Now, as we already mentioned a couple of times, Right to Information Act 2005, we need to know something. What is it? So here, basically, I have mentioned what the Right to Information Act, what it does. Basically, it seeks information from public authorities to promote transparency and accountability in government functioning, right? So in terms of coverage, it's applicable to central government, state government, and all public authorities. Even it is applicable to non-governmental NGOs or basically where government funding is more than 50%. So the time limit, in case let's suppose you ask for some information, in that case that must be provided within 30 days. But if it is regarding life and liberty matters, then it should be done within 48 hours. Now I have created a diagram for you, so you can just go through it and it will help you to memorize for longer time. So let's go through some practice questions which is relevant for government jobs. First, question number 1. Central Information Commission is established under which law? Option A, Article 324 of the Constitution, or option B, RTI Act 2005. So no need to read other options because we know it was established based on RTI Act 2005. So option B is the correct answer. Question number 2, the Central Information Commission consists of, we already know this is Chief Information Commissioner plus maximum 10 commissioners. So option B is the correct answer. Next, question number 3, who appoints Chief Information Commissioner and Information Commissioners? That we already know, that's President of India. Next, question number 4, the committee recommending names of appointment to CIC includes Prime Minister, Leader of Opposition in Lok Sabha, a Union Cabinet Minister. So you know all of them are included in that committee. So option D is the correct, 1, 2 and 3. Question number 5, after RTI Amendment Act 2019, tenure, salary of CIC and ICs are decided by central government. So before that, it was not central government. Actually, that was the some point of discussion. Now, critics told that basically uh, it will give more power to the ruling party. Now let's discuss those things later in some next video. So here it will be central government. So option C is the correct answer. Question number 6. Which of the following power is not available to the CIC? Option number A, summoning witness. Yeah, that is available. Option number B, ordering production of documents. That is also there. Option number C, punishing for contempt of court. No, this is not part of that power. So option number C is the correct answer. Question number 7. Maximum penalty CIC can impose on public information officer for non-compliance is, we know, that is 25,000 rupees. So option C is the correct answer. Question 8. State information commissioners are appointed by president. So state information commissioners are appointed by the governor. For central information commissioners, it is president, but for state, it is governor. So option B is the correct answer. Question number 9. Which Supreme Court case directed Union government to fill vacancies in CIC or SIC in a time-bound manner? That we already discussed. That is Anjali Bhardwaj versus Union of India case. So option C is the correct answer. Question 10. The right to information is derived from which fundamental rights? That we already know. That is Article 19 of 1 of A, freedom of speech and expression. So option B is the correct answer. Now let's go through some practice question which is relevant for UPSC. Question number 1. Consider the following statement regarding the Right to Information Act 2005. So statement number 1. It provides for establishment of central and state information commissions. Yeah, that is right. Now next, CIC and SIC have powers of civil court, including power to punish for contempt. Till this all was good, but including power to punish, that is not correct. So this is not correct. Next statement, information commissions are constitutional bodies. No, this is also not correct because it was created based on Right to Information Act 2005, Party Act, right? So that is a statutory body. So only option statement 1 is correct. So option A is the correct answer. Next, question number 2. Which article of the Constitution guarantees right to freedom of speech and expression? From which RTI is derived? Option B. Here we can see clearly Article 19 of 1 of A. So correct option is option B. Next, question number 3. Consider the following pairs. Here we could see few columns in the left side and related to is the right side. So what we know, Anjali Bhardwaj case, it's regarding appointment of CIC and SIC. So this last combination is correct. So we need to know which of the pair, that means how many. So 3 is correct, but if we check the options B, C, D, all has option 3. So now we need to check other things also. Now Indra Sawhney case, that is also I am telling you, that's regarding OBC reservation case. That means 2 is also correct. And first one, Waryam Singh case, that we know it's regarding High Court's power of superintendence. That means which option, the option has all the statement, that is the correct one. So option C, which has 1, 2 and 3 is the correct option. Question number 4. Which of the following writs can be issued by the High Courts but not necessarily by information commissioners? So here basically writs, only High Courts and Supreme Court issue writs, not the information commissioner, right? So that means here we can see all of the above should be the answer because mandamus, certiorari, habeas corpus, all can be issued by the High Courts. So answer D, all of the above is the correct answer. Question number 5. Which of the following is or are exempted from disclosure under Section 8 of the RTI Act 2005? That is under Section 8, right? Now, statement 1. Information prejudicial to national security. Yes, that is correct. Cabinet papers including deliberation to the Council of Ministers. That is also correct. Information relating to commercial, confidence, trade secrets. Yes, that is also correct. So, option D, 1, 2 and 3 is the correct answer. Now, next, we have mentioned a few main questions also. Question number 1. Right to information has strengthened participatory democracy and good governance in India. Discuss with examples. Then judicial review by High Court is a basic feature of the Constitution. Examine this statement with reference to landmark judgment. So check all these questions and try to write. So once you have prepared the question, please post that in your official Telegram channel. Next, we have a news item. Stealth frigate Udaigiri Himgiri to join Navy today. So here important keyword is frigates. Let's understand what is frigate. Frigate, if I have mentioned the picture here for frigate, destroyer, corvette and cruiser, and 2 more will be there. One will be aircraft carrier, another will be submarine. So frigate is, you just remember, smallest is the corvette, which basically being used by the coast guards. Okay. Next we have frigate, medium sized. And next we have destroyer, which is larger compared to the frigate and heavily armed. Next we have cruiser. Basically, this cruiser is used for long range of a strike and command operation. And, largest one is the aircraft carrier. And we have submarine that is basically works underwater. Here I have mentioned about all destroyer, corvette, cruiser, aircraft carrier, submarine. Please go through it. Next news item we have industrial growth jumps to 4 months high of 3.5%. This is a good sign, right? Now here important keywords is IIP. What is IIP? Index of Industrial Production. So now we'll go for some online facts on IIP. So it basically measures the short-term changes in volume or quantity of production. Okay, next its base year is 2011 to 12. Earlier it was 2004 to 5. Now in terms of coverage, mining has 14.37% weightage, manufacturing has for 77.63% weightage, and electricity has 7.99% weightage. Okay, now who basically publishes this index of industrial production? That is being released monthly by the National Statistical Office (NSO) under Ministry of Statistics and Program Implementation. So manufacturing has the highest weightage here, 77.63%. Now 8 core industries has 40.27%. What is the core industries? It's like coal, crude oil, fertilizer, steel, cement, electricity. Okay. Now here let's go through some practice questions on index of industrial production. Basically, this is one of the most important topics for any government jobs. Question number 1, the index of industrial production measures. Option A, price changes, no. Option B, quantity changes in industrial production, yes. So option B is the correct answer. No need to read other options. The current base year for IIP is it's 2011 to 12. It's simple fact, right? We know. So option C is the correct answer. Next question, which sector has the highest weightage in IIP? That is manufacturing. We know 77.63%. Now IIP is compiled and published by, we already know, that is NSO AMOSPI, National Statistical Office under Ministry of Statistics and Program Implementation. So option C is the correct answer. Next question 5. How many core industries are included in IIP? That is 8. Just remember this fact. Option C is the correct answer. Next question 6. Which of the following is not part of the 8 core industries? Fertilizer, electricity, automobiles, crude oil. Here option correct answer will be automobiles. Though automobiles is part of the manufacturing, but it's not part of the 8 core industries. So option C is the correct answer. Next question 7. IIP is released, it's monthly. Okay, so it's usually on every 12th of a month. It gets released. So option B is the correct answer. Next question 8. Which type of index is IIP? Just remember this. It's less pairs index. Option B is the correct answer. Question 9. What is the weightage of minimum mining sector in IIP? That is 14.37%. You need to remember this thing. So option A is the correct answer. Last question 10. That is IIP primarily serve as a. So option A is the measure of inflation. Option B is a leading indicator of industrial activity. Option C is a tool for measuring foreign trade. Option D is a fiscal deficit tracker. No. So option B, a leading indicator of industrial activity. That is the correct answer. So option B is the correct answer. Thus we have covered almost all the important news items and its relevant or corresponding static part also. So please go through this the video, and once video is done, please go through the document as well. Please let me know for any confusion. So now let's finish the session with the quote, with the below quote. Either you run the day or the day runs you. Thank you again.